Yes, Mr. Nicoventures.
Good morning, my lords. I appear with Mr. Alkin for the appellants, Philip Morris, and my learned friends, Mr. Speck, KC, and Ms. Pickard, appear for the respondents, who collectively are referred to as BAT. My lords will see and will know that Philip Morris and BAT are both in the tobacco industry, and this appeal concerns products referred to as heat not burn products, in which tobacco is heated but does not combust. The action originally started with a revocation action against 4 of Philip Morris's divisional patents. The issues on this appeal can all be determined on one of them, which is EP 486. Just so my lords, to update my lords, since the trial, EP 486 has been upheld on amended claims by the opposition division of the EPO. That was last April. The amendments don't matter for today, they don't affect things for today, and in any event, both sides are appealing that decision, as my lords will know is quite usual, and there's no date for a technical board of appeal hearing, and that's likely to be some years away. Of the other patents, 2 of them, EP 483 and 485, have also been upheld on amended claims, and one, EP 484, has been revoked, and that decision is not appealed. The focus of that claim is not the features that my lords will be looking at today. So there are 2 other divisionals, and just as below, we accept that if we fail on the appeal today, or any further appeal, then those 2 patents would also fall to be revoked with 486. And if we succeed on the appeal, then the claimed features would need to be brought into claim 1 of the other 2 patents, as was below. They're in subclaims at the moment. That is not a matter for my lords. It's likely to be a matter for relief if the appeal succeeds. And the reason I say that is my lords would have seen that the judge did not deal with infringement or added matter, which were in issue below. We say that BAT's resistive glow products infringe the patents. If this appeal succeeds, the judge indicated that these issues should either be determined by this court or revert to the Patents Court. My Lord Justice Arnold, in giving permission to appeal, indicated that if the appeal is successful, the issues should be remitted. As regards added matter, although points are made about it by my learned friend, we say it is important to understand that there are in fact no added matter objections to claim 1 of EP 486. The only objection outstanding is obviousness, which is before you, my lords, and therefore it would only be infringement that would be remitted if we were successful. There is an added matter objection to a single subclaim, but we've already indicated below that if that proved to be correct, we would delete it. And so the only live additional issue on EP 486 would be infringement. Now, on this appeal, my lords, I intend first briefly to introduce the technology and the common general knowledge at the priority date, and none of that is in dispute. I will then turn to the prior art, DV, and cover, as I go through that, the one dispute there is on its teaching, which is the subject of our 5th ground of appeal. And then I will turn to the invention in 486 and the claims, and then say what we say the judge ought to have found before showing you where we say he erred in his approach. So starting with the products, as I've said, the appeal concerns what are called heat not burn products. They are different from other alternatives to cigarettes. My lords will know of e-cigarettes or vaping products where an aerosol is heated, which is often flavoured. The idea of a heat not burn product is to heat tobacco, which is often impregnated with propylene glycol to help in aerosol formation. That produces an aerosol for inhalation, which the idea is it has a tobacco flavour which users enjoy, but avoids byproducts which are released by combustion. Now, the skilled team in the present case consists primarily of a product or heating engineer who work with a tobacco chemist on the team to design a heater according to their needs. And the judge heard evidence from 2 experts, Mr. Wensley for BAT, who was a heating engineer, and Mr. Hops from Philip Morris, who was a tobacco chemist. Mr. Wensley had no experience with heat-not-burn products or tobacco, but he gave evidence of general engineering concepts. Now, the priority date is October 2009, but since the 1980s, a huge amount of work and money had been spent, particularly by the tobacco industry, on seeking to develop heat-not-burn products which a user would actually enjoy using. And if I may, I'll just take you to where the industry had got to by 2009. Again, it's not controversial. And I'll take it from Mr. Wensley's report. Essentially, the same information is in Mr. Hops's report. I'll go to Mr. Wensley's because that is where the judge took some of the figures from. And that's in Supplemental Bundle tab 7. And we can pick it up on page 125. And I'm going to use, that's bundle pages, which are the ones on the right in red at the bottom. And what Mr. Wensley sets out there is an illustration of a product called the Premier, and that was followed by one called Eclipse, which was very similar, and they were launched in the 1980s and 1990s, and as you can see, they look like cigarettes, but they were heated using a carbon tip at the end. You see there's a red, in figure 3, there's a red block headed heat source, and that would be heated, and then heat would be transferred over the tobacco along with things called flavour beads as the user sucked and took a puff. Now they were commercial failures because they effectively didn't taste very good. And so one sees the next generation on page 129, if we go to there, of the bundle. And this was called the Accord, product, which was launched by Philip Morris US in 1998 or thereabouts, so about 10 years before the priority date. And you can see from figure 9 at the top of page 129 that this used these sort of stubby like cigarette inserts, consumables, and they were inserted into a battery-powered handheld device and electrically heated. And you can see in the top there the image of someone holding the battery-powered device with the insert inside. And at the bottom of the page there, you can see figure 10, how the cigarette consumable was configured. It doesn't really matter for today's purposes. It had, what you can see there is a tobacco mat underneath the outer paper, and that was heated to produce the aerosol, and there was also a tobacco filler, like a plug in the middle for extra flavour. The important part for today was how it was heated, and one sees that if one turns back a page to 128. And what my lords will see there, and it's in the judgment as well, is a figure 7, where you see the consumable was inserted into and surrounded by heater blades or prongs, and there were 8 of these, and they were biased so as to clasp the consumable. And when a user took a puff, it would automatically fire a single heater blade, and this rapidly heated the area of the tobacco under, or the tobacco mat, under the blade. And you see that depicted in figure 8, where you see one of the blades or prongs in red. And that heated to produce the aerosol for inhalation. And it was a quick fire heating. It fired for a fixed duration of less than 2 seconds at a high heat. And on the next puff, the next blade would be fired, and you see that illustrated in the right-hand picture where you see the next one's gone red, and a fresh area of tobacco would produce the same result. And again, each blade is fired for the same fixed duration and fixed high heat. Once all 8 heater blades had been fired, a new consumable would be needed, and so this effectively gave a user 8 puffs. And this is all described from my lord's note in the judgment, paragraph 36, and nobody disputes it. Accord was followed in around 2006, 2007, so a couple of years before the priority date, by the heat bar And you see that on page 130 of the bundle. And although that looks slightly different, in effect it worked materially in the same way. And you can see an image of its heater blades on page 131, where there's a breakdown of them, and that's the heat bar blades, but they work in the same way as we saw with a cord. Now, the judge held that the way in which both the cord and heat bar products worked represented the common general knowledge of heat not burn products by 2009, and a skilled team would be very well aware of both of these products. Now, the reason for this, what we call flash or pulse heating for a fixed period of time and a fixed temperature, was that there was a perceived benefit at the priority date to this form of fixed-duration sequential heating in terms of ensuring both consistency of heating and of consistency of aerosol produced with each puff. The idea is to ensure that the user gets, if you like, the same hit from each puff. And for my Lord's note, that was Mr. Wensley evidence in tab 7 of this bundle, para 54, and Mr. Hopps's evidence, tab 8, paras 169 and 170. And this approach to heating heat not burn products was common general knowledge in 2009 and had been taken by the priority date for around 10 years. Now, with that, my Lord, it's now, if we may turn to the DV prior art. And this you find in the same bundle at tab 5, page 67. And DV is another patent from, or a patent from Philip Morris Incorporated in the US. And it's an early one. It dates from 1994. So we're now going back in time, and it predates a cord by about 4 years, and it predates heat bar by about 12 years, and it's about 15 years before the patent. So it's an early Philip Morris idea, and it's a paper proposal. There's no evidence that it itself was ever progressed, and perhaps the reason for that can be seen in that neither expert thought it was very practical as a proposal. The main problem, as I'll show you, is that it teaches coating tobacco on heater tracks, or actually forming the tracks with the tobacco, so like a slurry, and therefore after 10 puffs, that is all consumed and gone, and the heater must be thrown away. And that was something both experts thought would be thought of as commercially unattractive and impractical. And you can see the practicality was not something at the forefront of the DV idea. It suggests even using gold or silver as conductive material in the disposable heater in column 5, lines 9 to 13. So there was no dispute that no one would think that it was a very practical idea. DV does not use heater prongs, as in a cord. And although the figure, my lords, have seen in front of you on page 67 on the left, those prongs that have a 114 next to them, that is the heater arrangement. Although they look like prongs, actually what it uses is what's called a thin film heater. Now, thin film heaters are heater traces or tracks, so they're traces or tracks of resistive material, like a metal, which are placed on a flexible, non-conductive substrate, and therefore can be malleable into different shapes, and what DV uses it for is to make it a tubular shape. And they are like circuit boards, so they can provide very flexible heating. You can heat the whole thing, you can heat parts of it, you can do almost what you want with a thin film heater. And there is an image of one in Mr. Wensley's evidence. We don't need to leave DV, but if my lords want to just see one, it is in tab 7, page 113. One can flick to that, and he gave an example of what a thin film heater is like, and you see there figure 2. And the particular thin film heater that DV promotes is one with a substrate made of a material called captain, and that is to withstand the high heat that it proposes. Now, the judge held that thin film heaters were common general knowledge by 2009. Indeed, he held they were ubiquitous even in 1994 when DV was written or published. And they were very well-known ways of creating flexible heaters. He found they'd been introduced in the 1960s, and it was well known they could be used to heat in different ways. So you could use different parts or elements that could be heated, and of course their substrate made them flexible and malleable. And for my Lord's note, that is the judgment on pages 132 and 133, particularly paragraph 1194C. So these are very well known and have been for a very long time before the priority date. Deavy's idea was to use one of these well-known thin film heaters, coat the heater tracks with tobacco substrate or make them up with it, roll it into a cigarette shape and insert it for heating in a battery device. And one can see the arrangement of the heater, and it's maybe easier, my lords, to see that from the judgment because they are coloured there. If my lords wouldn't mind some bundle shuffling, if one keeps DV out and just goes to the core bundles of the judgment, I'm only doing this because you see the coloured drawings, and that is in tab 8 of core, the judgment is, and it's at page 100, bundle. And what you'll see there is the judge has set out the drawing we were just looking at from DV, but you can see the different components rather easily with the colours. And on the right-hand side, the yellow and the purple is the battery pack, and on the left-hand side is the consumable, which will be thrown away, and that has the heater in it and the heater elements in a sort of orangey colour. And you'll see the judge explains at 43 1B at the bottom of that page that it worked by the heater elements are coated with a flavour generating medium, which can be tobacco, and then the several heating elements are sequentially heated to form an aerosol. So this, like the later accord and the even later heat bar, sequentially heats. And then the judge described 2 pages on page 102 or coloured in what the heater arrangement looked like, and what you have at the beginning on figure 6 it's rolled out flat, and you're looking, if you like, from above, and then figure 7 you have a cross section of the heater construction. And you'll see what you have if we take the cross section, you have heater connectors in blue. These are low resistance materials, so they don't heat, and they connect the high resistance heater material, which is in red. And then there's a low resistance common connector in purple at the top, and it has a shared connector. And then on top of the part that's heated, the heater element, is the flavour generating medium, or the tobacco, and that's in green. And when you look from above, you can't see the heater elements, but they're under the green. And then you have the blue connectors, which go down to little teeth at the bottom, and a common connector in purple. And the judge then gave a bit further information as to how it works. And if one turns over the page in the judgment to page 103, little 7 and 8, he explained that each heater element is covered in the tobacco and producing the aerosol. And then at little 8, sorry, that's 7, and then at 8, each heater element is activated. That vaporizes the small amount of coating, and that produces an aerosol. In operation, DV contemplates spiking the temperature to at least 450 degrees C with a pulse of less than 1 second. 10 such heat elements are shown, and when all 10 charges are spent, it's discarded. So we say what you see there, it's an earlier idea, but it's the same heating idea, as was later used in accord and then in heat bar, of this short, sharp, sequential pulse heating. My lords, if we just go back to DV in the supplemental bundle tab 5 and leave the judgment for a moment, although we'll have to go back to the judgment relatively soon, just to pick up a couple of bits of the teaching for my lords, and if one goes to column 2 of DV on page 70, at the bottom of column 2, line 65, it explains that by providing individual charges for each puff, one reduces the total amount of flavour generating medium, that's the tobacco and propylene glycol, that must be provided as compared with a single larger charge. So DV is promoting this small amount of material, and then you see how it does that in column 4, just across, which the judge referred to. Column 4, lines 6 to 12, is either you have the flavour generating medium deposited on each heater element, or they can be mixed when the heating elements are actually made. I won't go to it, my lord, it's a detail that's unnecessary, but it's like a screen printing method to make the resistive traces, and the tobacco could be mixed in as you make it and then printed on the substrate. So it's a very small amount of material. And then just for my lord's note over the page, column 5, this is what the judge I just showed you was referring to. Column 5, lines 35 to 39 is where it explains that the heater is heated to at least, desired it's heated to at least 450 degrees C during a pulse less than 1 second, and a maximum available energy input of 2.5 calories. Now, my lords, the only dispute on the teaching of DV that we're aware of concerns what is meant at the bottom of column 3. And if I may, my lord, it's convenient to do that now, although we have it actually as our appeal ground 5, but it is convenient since we're in DV to look at that now. And column 3, from lines 40 down to the bottom of that column, teaches two embodiments. One is a manual one, and one is an automatic one. And so the first you see at line 40, it says to operate the article, the consumer selects a heater element using a knob and presses a momentary on push button switch to complete the circuit and energize the selected heater to initiate heating. So what that is teaching is effectively a bit like a barrel of a gun. You move this knob around and it'll select which of the charges to fire. Now, it then says at line 59, when all 10 charges have been heated, you have to unplug the heater and throw it away. From line 63, it then says, well, this could be done automatically, effectively, and a more preferred embodiment, according to the present invention, includes controls that automatically select which charge will be heated, initiate heating in response to a certain stimulus, so it uses inhalation, and control the duration of heating of each flavour charge. Now, we say that that is effectively, a skilled person will understand that to be really what ended up happening in accord and heat bar, where the heating is initiated from the user's inhalation, and a controlled duration is used, a fixed duration, and in heat bar and accord it was under 2 seconds. In DV, as I've shown you, it's under 1 second. But that, the meaning of control the duration of heating for each flavour charge is disputed. And this matters, as I'll come to, because the claims of the patent require the heater tracks to have portions configured so that different portions are heated for different durations and or temperatures. And if this is heating different tracks for different durations, it is said it is closer to the claim, and indeed on the way the judge construed the claim, he, I think, thought it fell within it. We say it does not, because we say it doesn't teach portions of tracks. We also say it doesn't mean that at all, and no one reading it would think this is actually teaching controlling each heater for different durations. And that's not what a skilled person reading this either at the the time of DV or in 2009 would expect. They'd see it as what later happened in accord. And the judge considered this in the judgment, and if I may deal with that now, that is back in the judgment in core tab 8. And we are now finished with DV, so my lords can put DV away. And it's on page 137. And at the end of paragraph 132, I'll come back to the other reasoning, but what he says at the last 3 lines of 132 is there's a great deal of debate as to whether DV not only articulated its disposable version of portional heating, but also articulated a disclosure that electronic controls could be used to control the duration of heating. He then sets out DV that I've shown you and says, in my judgment, the words are clear. I do not see how duration can be controlled without it being capable of variation. Now, we say that is wrong. It is controlled. It doesn't require variation. It's controlled to a fixed duration and indeed fixed temperature. And no skilled person, we say, would read that one line in DV and think, now suddenly, not in accordance with the rest of the teaching, it's teaching varying the duration of heating per heating track. We also say not only would that be contrary to the rest of the teaching, it doesn't make any technical sense to heat a tiny amount of coated flavour charge for different durations. I mean, there's no point in heating for less than a second, and heating for longer would be wasteful and pointless because there's nothing left to heat. And so the judge didn't consider the technical approach and why anyone would think technically it makes sense to vary or have an ability to vary the heating of DV. And indeed, both experts understood that the technical purpose was for automatic initiation of a fixed pulse of heat. The judge didn't refer to that. He didn't refer to the technical background or to the understanding at all. But if my lords will go in the supplemental bundle to tab 11.
Just so that I'm clear, Mr. Nicoventures, you're not saying it doesn't teach varying the duration of the heating at all, are you? Or are you? I want to see where the argument bites. And one thing you could do, to my mind fairly obviously, with DV is allow the user to select the amount of time for which each of the tracks is heated, but change them all at the same time.
That obviously, that is right, my lord, it'd be all at the same time, but also we're saying that DV isn't even suggesting allowing the user to change that. My lord is right.
But it's saying you've got a control.
Well, it controls.
And it controls the duration.
That's right, because once it starts, it has to. The duration will be controlled by the system, which is.
So you're not saying
1 second.
Control in the sense of starting and stopping.
That's right.
Yeah, but not giving you any variation.
That's right. It's firing basically, and plainly the idea of this, as was in accord, is the heater doesn't just carry on heating when there's nothing left to heat.
But no user control.
But no user control, and so it remains a, if I put it this way, a cap gun approach. It fires and stops. What is right, my lord, is that it may not be that it has to be under 1 second, or it has to be. That would be a design issue as to how fast you want to do it. As I've shown you in accord, it was just, I think it was 1.97 seconds they did it. They had a bit more material. Here, DV is teaching under 1 second. So I can't say you'd read DV and think I have to do it for under 1 second. You would read DV as it's a short, sharp shot. And that, as I'll show you, is what Mr. Hobbs, I'll show you Mr. Hobbs and Mr. Wensley, because the judge didn't refer to this. And this is at page it was tab 11, and it's bundle page 308. And on page 308, there's some transcript of questions from my learned friend to Mr. Hobbs. And I think we can pick it up in little internal page 158 at line 21. My learned friend says the idea is powering the heater when user is puffing but not otherwise, but relying on the user pressing the button. And he said, I would view it as a marker. When a consumer starts to take a puff, the circuit will initiate, and that will be for a fixed duration. My learned friend then says, well, that's one way of reading it, but that doesn't control duration, he says. That's actually telling you can control the duration, which will control it so it's on while the puff continues, stop while after the puff continues. So I think the law, what my Lord Sir Christopher Floyd was just putting to me, and Mr. Hobbs said, I think given the very small amount of tobacco involved per each heater, the temperature it's getting to, reading the patent in general, it's quite clear their intention is never activate the heater for more than 1 second, irrespective of how long the consumer is puffing for. I view this as sensing the start of inhalation. And then my learned friend says that's not controlling the duration, that's having the same duration every time regardless. And he said yes. And that isn't, we say, entirely accords with the teaching of the document as a whole and the technical teaching. Just to see what Mr. Wensley said about it, that is in tab 13, under page 322. And at page 322, internal page 360, I think we could pick it up really just at line 10, internal page 360. We were talking about, I was asking him the questions about this teaching, and he said that what he was saying was that it would automatically select the charge that was to be heated. Well, that's obviously right. And then I said, and the teaching of this document is once it has selected that, that charge will then be heated at least for 450 degrees C during a pulse of less than 1 second. That is implied in that. Yes. Again, it's implied that that is exactly. There's no suggestion that this piece of teaching is teaching something different. So we say that the judge was wrong, with respect, to say that DV somehow teaches changing the duration either of one or all or some of the heat elements. Now with that, my lord, I'd like to turn to the patent, and that is in supplemental bundle tab 1 EP486. And the patent is directed to a heat-not-burn device which is electrically heated and effectively uses a thin film heater with heater tracks arranged on a flexible substrate. And we say the invention is the realization that a short, sharp, sequential pulse heating of fixed duration and fixed temperature that had been used for 10 years, it is too limiting, and a heater should be configured to provide more flexible heating. And in effect, rather than concentrating on consistency of puff, it's turning the focus on different heating profiles at different parts of the substrate and focus more on differing profiles rather than the same one each time. And that idea is discussed in column 4, paragraph 22 and 23, and on page 4 of the bundle. And as I say, my lord, there's no added matter objections about this. My friend makes some points in the skeleton, but there's no added matter against claiming of this patent. And we see in paragraph 22 that it talks about, in accordance with the invention, one or more electrically conductive tracks can comprise polarity of portions, each one connectable separately to the power supply. This provides a number of advantages. It allows the different portions to be heated for different durations, which may enhance the smoking experience, depending on the nature of the substrate. And there is evidence that, of course, even with tobacco, there are different tobaccos and different constituents of tobaccos, and therefore different approaches may be taken. Second, it allows different portions to be heated at different temperatures, which may enhance the smoking experience depending on the nature of the substrate. And third, it allows a particular portion of the heater to be activated at any one time, which allows a portion of the aerosol forming substrate to be heated at any one time. And that is then reflected in the claims. And one of the, we say, remarkable parts of the judgment, as I'll come to, is the judge never really focuses on the claims at all. I think they appear in one part of the judgment, showing where proposed amendments might be. But it's clearly important to look at the claims, and my lords will find those at page 10 of the Bible. And we're only interested in claim 1. And the idea that we've seen in paragraph 22 is reflected in the claims. You have an electrically heated smoking system for receiving an aerosol forming substrate. So that is akin to the sort of insert we saw in Accord and heat bar, and is not a DV type arrangement where it's coated. So it receives the substrate. We've got at least one heater for heating that substrate to form an aerosol. We have a power supply, and then the heater, it has got one or more electrically conductive tracks on an electrically insulated substrate. And we accept that that is apt to describe a thin film heater. There are tracks on a substrate. But then it goes on, the one or more conductive tracks comprising a plurality of portions, each portion being separately connectable to the power supply. And then you have electrical circuitry arranged to control the supply of power from the power supply to at least one heater, so that, and I emphasise so that, different portions of one or more electrically conductive tracks are heated, and I emphasise that. It's a smoking system where this must happen. So it's so that the portions of the tracks are heated for different durations, or to different temperatures, or both. So we have to have different portions are heated for different durations or different temperatures, or both.
How does that work in a product claim, which I assume this is, that you actually require it to be heated as opposed to capable of heating? How does that work? So product only infringes when it's in use, or?
Well, the product, my lord, will be able to do that. For instance, if you picked up a DV or an Accord, it could not do that.
So it is capable of being heated?
Yes, but without modification. I think anything is capable of being changed to do something. You could change all the circuitry.
Yes.
But when you pick up that product, as we'll see, I'll show you, for this reason, I was going to show you the alleged infringement, because that is exactly what it does. It heats with a profile two portions for different temperatures and different durations.
So you look at the circuitry and say, can it do this, not is it doing this?
Well, you look at it and say, is it doing this? Well, it depends what you mean by what's loaded with can. If it's can because you could change the circuitry, we say that's out of it. If it's can because
that's what it is programmed to do.
It's programmed to do or configured to do.
Yeah.
As I say, if you picked up Accord or heat bar or DV, you couldn't do it. Now, before we leave the teaching of the patent, there's one paragraph my lord should see because it led to some confusion in the judgment, and that is back on page 4, paragraph 23. I've shown you paragraph 22, which is reflected in the claim. Paragraph 23 then talks about an embodiment where you have a single track, which, about a few lines down, may also be connectable to one or more central sections to provide a polarity of portions, each portions being separately connectable to the power supply. I don't know if you see where I'm reading, my lords. And at the end of 23, line 31, there it says there's another embodiment where the electrically conductive track or tracks comprise a plurality of tracks of electrically conductive material, each track being separately connectable to the power supply. But that final embodiment doesn't refer to portions, it refers to separately connectable tracks. And I point that out, I'll show you that caused some confusion with respect with the judge, our case is that whilst that is an embodiment that is discussed in the patent, that is not the one claimed. And I will see what the judge did with that in a moment.
It's odd that, isn't it? Because the specification up to that point is quite careful about talking about aspects of the disclosure rather than the invention. Then at 22 you come to in accordance with the invention, and at 23 you got to embodiments of the invention.
It is. It may be a function of the divisional nature, but my lord, we say it's clear when you read the claim.
Yeah, well, I understand that, but I haven't done the public a great service by the way in which this is presented.
My lord. Now, my lord, turning then to obviousness and what we say, I'm first address you on what we say the correct approach would be in this case, and then show you what the judge did and why we respectfully say he found error. Considering the differences in Pozzoli between the claim and DV, prior art, DV uses coated heater tracks and so does not receive an aerosol forming substrate. And DV does not teach the use of separately connectable portions of tracks which are arranged so that different portions are heated for different durations or temperatures or both. In fact, we say DV teaches away from that, teaching instead the conventional short burst of heat of a fixed duration and temperature sequentially by each heater track. And I say conventional, it may not have been conventional when DV was written, but it was by the time of the priority date, 15 years later. And in fact, we say that DV adds nothing to the later accord and heat bar, save that it uses or proposes using a thin film heater, whereas they used heater blades or prongs. But as I've shown you, the judge held that thin film heaters were common general knowledge and had been since at least the 1990s, where he said they were ubiquitous. And there is a short piece of evidence from my learned friend's expert, Mr. Wensley, which goes to that, and which the judge didn't refer to, but we say is worth keeping in mind when assessing how the judge approached it. And that is in Supplemental Bundle tab 13. Bundle page 323. And on bundle page 323, I should say the reason I'm showing you this, my lord, is because our criticism of the judge is that he didn't look, as I'll explain, he didn't properly analyse the differences between DV and the claim, and we say he didn't ask the right question, and in particular he completely, with respect, we say muddled up matters which could be done with what is obvious to do. And when we see this evidence, it gives a flavour of that. At 363 at the top, I was talking to Mr. Wensley, or asking questions, saying before you and Mr. Hops, both you and Mr. Hops, would not be attracted to, and this is DV, the idea of a heater element on one of these products being disposable, I think through wasted costs reasons. Is that fair? Yes. And both of you, I think, agree it's very difficult to render the heater reusable and keep either of DV's coating or mixing together concepts for the flavour generating medium. He goes and then subsequently depositing them directly onto the heating element. And I say it's quite difficult to use those concepts on a heater that's going to stay put. Again, if the concept is, yes, you're correct, you are correct. So you do have to discard the DV concept. So then if you go over to 365 line 6, I said, yes, well, if one just thinks, well, I'm not sure about the flavour charge, or I want to have a disposable heater and I cannot see how to do that with the flavour charge, DV's not really teaching anything over what you say the skilled person would know anyway. I believe that is true. And the judge agreed with him and found that the thin film heater was common general knowledge and ubiquitous. And then at line 18, I said it's not going to be a starting point for anyone for further development if they do not want to develop the flavour coating concept in DV. And his answer was, he said it's hard to say where the starting point for people is. Again, that's usually within a company, some sort of business drive. certainly nobody would look at DV in a company and go, aha, we now can build a heat not burn product because I've read DV and now I'm going to start down this road. And then he says DV would be one of many things they'd look at now about whether it's a starting point I cannot say. But we say that alarm bell should be ringing about going to a 15-year-old document, the main thrust of which has to be discarded, and the part that one takes is common general knowledge. And as I'll show you, my lord, the other part, which is fixed duration heating, one also has to discard. So turning now, so we say that on a proper approach, if one looks at the differences and considers the issue, we say correctly, it is not obvious over DV. Now, the judge held differently, and I need to show you why. And orally, I'm going to bring our grounds 1 to 4 together into 3 principal errors, which we say the judge made. The first is he misconstrued the claim. That's our ground 1. He effectively wrote out the limitation to have different portions heated to different durations and or temperatures. The second, which is our grounds 2 to 4, is that he asked the wrong question on obviousness and wrongly approached obviousness. And we say this, looking at the judgment, arose primarily for 2 reasons. Firstly, he didn't properly identify the differences between DV and the patent. And he also confused the question of what is possible to do, or what is within the skill of the skill team, with what is obvious to do in a light of a piece of prior art and the common general knowledge. Our third specific point, which is raised in our ground 3, paragraph 8, is that he also overlooked the only evidence before the court from a tobacco chemist that changing the heating profile used in accord and DV would not be obvious. And that's not, I'm not asking the court to re-evaluate evidence. We say the judge ignored that evidence, or I think potentially, with respect, didn't understand its relevance because he was thinking, if you can do it, that's enough. So starting with our first ground of appeal, and my learned friends do not put up much resistance to this because the judge plainly erred, but in our submission. But going to the judgment, page 137, where we were.
As I read the Skeleton argument, they don't resist your construction of the claim, but they make 2 points. One, they say that will have consequences for infringement, which of course we're not concerned with. But 2, so far as obviousness is concerned, they say it doesn't matter.
That's right, my lord. And if that's, and I can show you why it does. It may matter in the sense of DV if one reads DV as teaching varying duration of different heater tracks. Now, of course, the judge held that would be within the claim. We say it isn't, because you still don't have the portions of the tracks. But on the judge's construction, if you take his construction of the claim and his construction of DV, then you have DV teaching very different tracks to different durations, and he says that's what in relation to infringement, that is not before my lords, we say that we had always maintain a case of infringement based on claim and against the portions, and we say they have a single track with 2 different portions. And indeed, just very briefly, so that my lords, it's actually quite illustrative also of the difference between the prior art and what we say the patent is teaching. If one goes to the supplemental bundle, tab 6, page 89, this is the PPD, but we can very quickly see what we say that the difference is we say, and there's a dispute on this, that what you see there is a single piece of metal track in 2 portions, the left and the right. Muller and friends dispute that they say it's 2 tracks. And that's not a matter before you, my lords. We say it's got 2 portions, and you see in paragraph 25 they refer to them as heating zones. You've got a first and a second heating zone. And what they do, if you turn over the page to page 90, you can see the plots of the control set points. One heating zone is in blue, the other heating zone, which we say are portions, is in red, and they're heated for different temperatures, or controlled for different temperatures, different durations. And over the page again, that results in a temperature plot that you see there between the blue and the orange. And we say that that would be a very stark contrast to DV, where you would have a line going straight up in under a second to 450 degrees C. And it would be very different from accord or heat bar, where you would have a line for each heater track, so a single line for each heater track, or prong, sorry, going up, I think it was slightly higher than 450 in accord, in under 2 seconds. So a very different approach, and we don't accept that the construction affects our infringement case. In fact, our infringement read was always on the construction I am submitting to my lords. So, my lords, going back briefly, I can take relatively quickly, therefore, how the judge dealt with this, and my lords will see that on page 137 of the judgment in your bundle. And what he's done is he started the discussion of obviousness the page before, and then he turns to construction, and he says at the bottom, he asked the question, were the patents claiming, and then turning over the page, top of 138, multiple separately connected tracks, and or a single track with a polarity of portions, each portion being separately controllable, connectable to the power supply. Now, stopping there, we actually say neither of those is correct, and he hasn't gone back to the claims. The second is closer, but of course the claims are not limited to a single track, and also they require the portions to be heated for different durations or temperatures, or both, or different portions to be heated for different temperatures, or both. So we actually say neither of those is correct. He then says, in short, the question is whether what is being claimed is the concept of a wholly separate tracks, where current cannot flow from one track into another, or a single track that is electrically continuous, but has separately controllable portions. Now, again, that is, in our submission, a little confusing. What we think he's referring to here is actually a non-infringement argument that BAT were running, and they may still be running, on the meaning of track. And BAT argued that a track is defined by where current flows, and on that meaning they said that they didn't have they had 2 tracks, not one. We said a track is defined by the physical piece of electrically conductive material which heats. That's the track. That was a dispute on infringement. It's not, to our submission, very relevant, and I'm not quite sure why the judge thought it was. He then comes back at 136 to quote the 2 parts of the specification I've shown you, and in particular homing in the end of paragraph 23, where you have this reference to the tracks rather than the portions. And then at 137, he says the underlined words do indeed support BAT's contention. I have, in particular, the bolded lines. It's quite clear that both of the alternatives in 134 are being claimed. And I think when you read what he goes on to say, what he means is it's enough to have multiple electrically conductive tracks rather than having portions. And we say that's plainly wrong. At best, both are described, but they're not claimed. And the difficulty with all this is the court had not reminded itself of the wording of the claims. At paragraph 138, he then says, well, it's unsurprising the patents articulate both alternatives, whether portional heating is achieved through a single track with controllable portions or multiple tracks all on the same flexible substrate seems to me to be a distinction without a difference. We say they are different. Connectable portions permits the use of fewer connections and potentially provides greater flexibility, but we accept that the flexible zoned heating the patent talks about could be achieved by both, could be, but the point is only one is claimed, and the judge was wrong to say otherwise. Now, my learned friend, I should deal with one point. He says it was we who gave him the wrong target, and this is part of his case that we've changed our construction now before you when infringement's not an issue. I should deal with that briefly, although I think it's more of a jury point, if I put it that way, or prejudice point. It stems from our opening skeleton, and it is in supplemental 14, page 326. Supplemental bundle, tab 14, page 326. And what we had done at the beginning of our skeleton, we'd set out a question for obviousness. In A, we had set out the reference to the polarity of portions, but in B, we had said wherein one or more electrically conductive tracks are heated, rather than different portions, for different durations or different temperatures, or both. So that's what my own friend is referring to, and that is also set out in the judgment. But if one turns a few pages on to page 329, we were very clear what the portions concept that we were talking about was, and it was very clear in our evidence. And you see at para 123, 329, our case, suffice to say at present, the dispute is not whether it's possible to arrange control circuitry in a thin film heater to heat different portions of a heating tract at different durations or at different temperatures, or that this could be done, that it was possible. The issue is whether it would be an obvious thing to do in light of DV and the common general knowledge, and that is a different question entirely, and we say the judge misunderstood that. And just to make sure there's no doubt on this, if my lords would also just take tab 11, bundle page 300, in little page 16. This is my oral opening. And on little page 16 on page 300, I explain the importance of the claim. I set out what claim 1 is, and we've said that's called the portion concept, line 7. I then read on in line 10 to say that the heater has to have one or more, comprising one or more electrically conductive tracks, polarity of portions. It can, as we've seen, be one track, the number of portions. Each portion is being separately connectable to the power supply. Electrical circuit is arranged to control the supply of power, so at least one heater, so that different portions are heated for different durations and or different temperatures. I then say we accept that what is described there in terms of electrically conductive tracks on electrically insulating substrate is apt to describe a thin film heater. We accept that before you, my lords. So, but I say, however, this is line 23, we say what's very important is it's not just using a thin film heater. It has these portions being separately connectable so they are heated for different durations or different temperatures or both. We say this portions concept is an entirely different concept to the existing heat not burn products, and I go on to say the same about DV. Now, my lords, we don't need to go to them, but if this point has any traction, for my lords, note that was also made clear in our oral opening in tab 11 at transcript, internal page 20, lines 10 to 17, internal page 22, lines 16 to 25, internal page 23, lines 12 to 17, and we've added the relevant portions of our written closing in tab 15 of the supplemental bundle, which again has this very clearly set out in around 8 paragraphs, different paragraphs, 4 to 5, 30, 39, 79 to 84, 97, 114, 127, 133. So we entirely reject the suggestion that we've either switched horses now, or that we weren't clear for the judge. Well, that is ground 1 of our appeal. Turning now to grounds 2 to 4, which I'll take together. And we say one of the problems with respect in the judgment is not identifying the differences between DV and the patent, and confusing the question of what is possible to do, and within the skill of the team to do, with what is obvious to do in light of the piece of prior art. And as I've shown you, I made it very clear in opening that he needed to be extremely careful about that, and with respect we say he went wrong. So if we go to the judgment, and I'd like to pick it up on page 137. Of the bundle. And paragraph 132, he says, this is before he talks about construction, but he says, leaving on one side for the moment the portions element of the claim, he is aware that there is a portions element of the claim, and focusing on a single electrically conductive track, it is quite obvious, indeed it was known and done before the priority date, that that single track could be heated for different durations or to different temperatures, or both. There is nothing that is not old technology here. Now, stopping there, we say the important word there is could. His reference to this being known and old technology and done before the priority date can only be to what he had found earlier at paragraph 119 4c, about the common general knowledge for decades that thin film heaters can be heated in any configuration. And we accept that thin film heaters are old technology. They were from the 1960s, and that you could do almost anything with them. But we say that's not the question. The question is whether it's obvious to heat a heat not burn product for different durations or different temperatures or both, or in fact you need portions, in light of DV and the common general knowledge. And we say he's already gone wrong. He then considers DV and thinks that that might be any way taught in DV, and I've addressed my lords on that at the end of 132. And then at 133, he says, I turn to what Mr. Hops considered to be the inventive part of the concept, namely the notion of heating portions. And he says the fact is that portional heating of a tobacco product was well known in both DV and in the Accord heat bar devices, as I have described. The question is whether achieving this end by means of a thin film heater was obvious. We say that's not the question. And unfortunately, he uses this portmanteau term of portional heating. But we say he's right in the sense that Accord heat bar and DV heat portions. They heat the portion that's under the heater trace or track. But he's wrong with respect that that is what the claim is talking about. And so the fact that it might be well known to heat in the way of DV and Accord heat bar actually points away from the claim, not towards it. And we say the question is not whether achieving this end by means of a thin film heater is obvious. The question is whether it is obvious to use a thin film heater and then modify that heater to operate in the way of the patent. And in fact, he then at the end of this raises the question that troubled him as why no one had ever used a thin film heater at all before the priority date. It might mean that a heater to heat portions is not obvious. In the end, he decided it was. Well, we say the reason is because he was asking the wrong question. He then goes to the part we looked at, which is the construction of the claims, and we say that he got wrong. And then he comes back to answering the question he posed. And he does that in paragraph 139 on page 139. And he starts, the question is whether using a thin film heater in this portional way to heat portions of the tobacco product. Now, stopping there, now he's talking about in this portional way. This comes directly after the paragraph in 138, which I showed you, where he says the patent articulated two ways of doing it, a single track with controllable portions or multiple tracks. And he now seems to be wondering now whether heating in this portional way was obvious, and that's fine, although it's the claim. But then you have to look as to his reasoning as to why. And he says, I am in no doubt that it would be. He quotes Mr. Wensley's evidence, which simply says that thin film heaters could be used in that way, which is right. He quotes Mr. Hobbs, who actually, from the tobacco chemist's point of view, pointed out that the way of heating was completely different. And you see at the end of that evidence, he says, 3 lines up from the bottom in little 2, further I've explained how heat-not-burn products known at the prior date operated, and there's nothing in the common general knowledge that would point towards this modification. And of course, DV doesn't point towards it either. Stopping there, my final, when I come to my third point, we said there was no grounds to dismiss that because Mr. Wensley couldn't give evidence and didn't purport to give evidence from someone actually working in the tobacco industry as a tobacco chemist. Mr. Wensley only gave the general engineering evidence. And then we have how the judge dealt with it in 3, and I think the nub of it is actually over the page in C and D in my submission. In C, he's asking himself, in light of the obvious need to render the heater reusable, so this is the obvious need to do something about DV, because DV doesn't work very well, or not in a way that is viable. It seems to me, for reasons I've given, that moving to a tubular heater structure designed to hold an insertable tobacco product, so making it like a cord with a thin film heater, would be obvious. This would have been all the more obvious because the step would bring the user the device much closer to the experience of a cigarette, and the insert is very obvious and one that was used in a cord and heat bar. So he's created, effectively, a cord and heat bar with a thin film heater. And that was the question he posed himself at the outset.
There's nothing wrong with that, is there?
No, we're not attacking that.
Right.
I mean, we do have issues about whether you do anything with DV at all, but I'm not putting a case before you, my lords, that you wouldn't do a thin film heater with a cord.
Right. So he gets as far as doing what's in C.
Yes, and then D, clearly the engineer who'd be part of the skill team would defer to the tobacco chemist, and my lords would have seen in the judgment that through most of this judgment he didn't criticise Mr. Hobbs, but he said that Mr. Hobbs's evidence was not as relevant because he saw it as a heater design matter. But you have the engineer deferring to the tobacco chemist to understand how best to heat the insertable tobacco product to achieve the best experience. This would involve articulating the duration, precisely the durations, temperature, manner in which to be heated. Having obtained these details, it would be obvious to the skill team that you could configure the heater to achieve that desired aim. Now, stopping there for a moment, my lord, we say that this is not, he's forgetting why is this obvious from DV or the common general knowledge. He's right that one might want to articulate precisely whether it's the 2 seconds, 1.5 seconds, whatever duration, fixed duration you're going to. You're right, he's right that the temperature may be different. We've seen that a cord had DV had 450 degrees C. A cord, I think, was slightly different. But where we say he's wrong is to suggest somehow that suddenly everything is up for grabs when trying to implement DV. It's not entirely clear in our submission what he did have in mind other than a cord, and you see that in E. If you go over the page, and this is a paragraph my own friends rely on quite heavily in their skeleton because they say it's a finding against me of obvious to try. But if you look what he says it would, if the tobacco chemist considered it desirable, and then there's a footnote 1, 2, 3. And if my lords could just read to yourselves that footnote. So what he's done, sorry, my lord, have you, may I proceed? So what he's done in 1, 2, 3, again, in our submission, is saying, well, what would be desirable would be to do something like a cooled heat bar, because that's portional heating. But I've explained the difference that he overlooked in the sort of heating that the claim requires to what were called heat bars. They're completely different. So in our submission, what he's actually positing is making a cooled heat bar with a thin film heater. He then says the notion of portional heating, I'm back in little e, would be known to the skilled team from a cooled heat bar. Again, that's not the heating of the claims. And translating that functionality to the tube would be entirely straightforward and obvious. Stopping there, we're not fighting that. I'm not fighting before my lords or quarrelling whether you could do a cooled heat bar with a thin film heater. My quarrel is that that's not within the claim. And he says you could do that through the use of portional heating techniques, which he described in paragraphs 134 to 138. Those are the paragraphs when he's discussing the patented ideas of portions, multiple portions or multiple tracks. I cannot say which approach would commend itself to the skilled team, a single track with controllable portions or multiple tracks on the same substrate. Both would be obvious to try. But we say, not in light of DV, and not in light of the common general knowledge of heat not burn products. He's completely conflated what the patent has taught. My lord, finally, we have what he says might be done by the tobacco chemist. And we say up to this point, the person he'd been most focused on was Mr. Wensley and the engineer, and effectively he accepted the evidence that anything is possible, and thin film heaters were known and had been known for decades. We say that doesn't get our own friend to the claim. As I've shown you, the judge thought differently. But the judge has, I've shown you, mentioned a couple of times what the heating and tobacco engineer might do. And I've shown you in E that he's got in mind making a cord and heat bar, and he just doesn't, with respect, the judge just didn't see the distinction. And that, I think, partly is not focusing on the claims. But he does also have a very long footnote on page 140, which I need to address you on, and that brings me also to my third overall criticism. And if my lords would just read footnote 120 on page 140 of the bundle. It's quite a long footnote. And we make just a few submissions on that. Firstly, he doesn't conclude, he says actually, it cannot be said what sort of heating profile would be best. And he says, in effect, it's obvious to try multiple heating profiles, multiple inserts, and effectively undertake a research project, all of which would be in the skill of a skilled person. And we make 2 points. First, we say again it betrays the confusion with asking what is possible to do within the skill and what is obvious to do in light of a piece of prior art. He doesn't ask himself why it would be obvious to do any of this in light of DV. And indeed, in our submission, he's rather lost sight of DV. A team practicing DV would not be trying all these multiple options and profiles and the like. They would be undertaking sequential pulse heating. In fact, if one followed this analysis through, there's nothing left of DV other than a thin film heater, which the judge held was common general knowledge and ubiquitous anyway. So we've already discarded the disposable coated heater in favour of a cigarette insert. We're now discarding the way of heating taught in DV and the manner that the heater is constructed in favour of an empirical research project which the patented idea might arise, but he can't even find that it would. What he does find is whatever the tobacco engineer would think was the right thing to do, the heating engineer could achieve. But that doesn't help my learned friend, we say, and certainly doesn't render this obvious. It's patent obvious. And we say, actually, it is contrary to the evidence before the court from the tobacco expert, and the judge himself quoted that. He doesn't directly say it's wrong, he just quotes it, and that was at paragraph 139, and I showed my lord that, where purely in terms of what the judge is talking about in 120, Mr. Hobbs didn't say that. He says actually that whilst there is a process of optimising tobacco volatiles, he says that in the middle, he calls it a significant difference with what's done in DV and the fixed pulses of energy. And he actually said he didn't think that would be something that would come to mind from DV or the common general knowledge. So, and there's no reason for the judge to ignore or not take this evidence, because Mr. Wensley wasn't giving evidence quite openly on those areas of the case. It may be that the judge was confused by some of the evidence given by Mr. Hobbs as to the capabilities of the tobacco chemists. And if my lord goes to the supplemental bundle, tab 10, page 287. And at 287, he was answering the fact that Mr. Wensley said effectively you could do all these things. And he said, well, you could, but why? And he says at 49A, he sets out the portions concept in bold and about the heating of the portions. And he says this is conceptually very different from the short on-off flash heating seen in a cordon heat bar. But it may be what the judge had in mind was over the page. Having said at 51 that this was entirely new, and it was actually of interest to him as a tobacco chemist, because none of the devices made use of that, he said that at 53, that although the patents, had been pointed out, the patents do not identify specific durations or temperatures, he said once the skill team has been informed of the portions concept through reading the Grimm patents, the skill team would, in my view, readily appreciate the utility and will be able to work out desirable heating profiles with routine trial and error. Now, it may be that's what the judge had in mind. So it is possible to do it, because obviously different materials you use, different tobaccos and the like, can come to different heating profiles, temperatures, durations and the like. But that, we say, is not, cannot then be translated into what the judge is suggesting, which is it's all up for grabs. He doesn't know what they might do. They might do anything, and the patent is obvious as a result. And that is not the right approach. And again, it is confusing the question of obviousness with the question of the skill of the team.
Just putting aside the question of fixed pulse versus varying the duration. The evidence was that this was the expert regarded as a departure. Is there comparing the use of multiple tracks forms one part of your claim, one embodiment of your could be said on the description to be one part of the invention, and portions of a single track. And what is the technical difference between the two? What does one provide that the other doesn't?
As I said to my lord, I think with the portions due, I think the evidence of Mr. Hobbs was that it provides ability to have fewer connections. But I accept, my lord, that
I can't quite see the fewer connections point.
I think in the end you can have connections either side. You can have a common connector, basically, where it's very difficult to do that with separate tracks.
Well, separate tracks do have a common connector
They,
at the top and separate connectors at the bottom. If you have a single
indeed.
track, you have to have connectors all the way along.
my lord, we on this side of the court accept that, and the patent says that the end result can be achieved with separate tracks heated for different portions, for different durations and temperatures. The claim does claim portions. My lord's seen that. But I'm not going to argue with my lord that actually you couldn't achieve the result with lots of separate tracks heated separately. But what you do have to achieve that result is the idea of heating those tracks different tracks for different durations and different temperatures.
So you say that, I mean, if the claim does cover both embodiments, you say neither is obvious because of the different temperature, different duration point.
It's the way they're configured, that's right. And we say that if we are wrong on DV, the construction of DV, we still say it doesn't teach different
Portions.
Or different temperatures, actually, for different. I mean, there's no reason why you'd have different temperatures for different tracks. And that's again just reading more and more into DV because you know what you're aiming for.
Thank you.
My lord, perhaps we say, knowing there's an issue with his evidence, my learned friend in his skeleton says there is evidence whereby different heating temperatures and maybe durations could be an obvious thing to do. And he refers to that in his skeleton, and I should deal with that. If you see, just so my lord to know where it is, it's in his skeleton, which is in Core Bundle tab 2, paragraph 36. It's on page 38. And in paragraph 36, he says the second sentence, the question of whether it would have been obvious to use different heating profiles, different parts of the heater, different temperatures, was the subject of cross-examination. And he quotes T2, page 192 to 194. My lords, I'll let my learned friend develop this if he wishes to, but my lords may wish to have a note next to that to see also supplemental bundle tab 11, page 303, internal page 129, and bundle page 309, internal page 170 and 171. Now what my learned friend is referring to here is his attempt to shore up the position by putting to Mr. Hobbs evidence from an expert in an earlier case between these parties, before Mr. Justice Mead, and it was an expert called Dr. McLaughlin. And my learned friend used this to suggest that it might be obvious to undertake some preheating of a heat-not-burn product, i.e. heating at a lower temperature before it's used. And the suggestion was this might be a good idea to save energy by preheating up to a certain level before you get going with the puff, or even I think it was put it might assist on a cold day to get you up to temperature or nearer temperature, so you're not, if you like, going from a standing start. Now, neither expert suggested in this case that this was an obvious thing to do, and indeed in the parts I've quoted or taken you to, Mr. Hobbs didn't accept this would be done, or obvious to do, with a pulse or flash heating such as taught in DV, and one can see why. There's no point preheating tobacco to get up to temperature before use if you're heating in a flash of less than a second. There was no evidence this was done in a cord. There was a suggestion, although it wasn't in the evidence in this case, there was a suggestion that a cord may have had some form of pyro heating function to clean its blades. That was never explored because it wasn't mentioned by either expert in this case. And of course it doesn't get my learned friend anywhere because his obviousness case assumes you remove the heater blades of a cord anyway. Certainly, there's no evidence of a cord or heat bar having any form of preheating function. And again, that goes to the fact that it's not needed with a flash heating type device. So we say this goes nowhere, but perhaps most importantly, the judge rejected this, and we say rightly rejected it, and that is in the judgment in tab 8 in the core bundle at page 92. And in paragraph 16, this is what he's referring to. He said considerable reference was made to the evidence and proceedings before Mr. Justice Mead and that judge's decision in Philip Morris versus RAI. I was not assisted by this. Whilst the issues before me and Mr. Justice Mead were in some respects similar, these common issues were factual in nature. Both Mr. Justice Mead and I are obliged to decide the issues before us on the evidence adduced before us. Mr. Hops, in particular, was often cross-examined through the prism of evidence that was produced not by him, but in the earlier Philip Morris case, and that's the evidence of this Dr. McLaughlin. Whilst Mr. Hops did his best to answer questions, so put, and whilst I have, of course, paid full account of his answers, given the complex and nuanced nature of the evidence before Mr. Justice Mead, and me in this case, I was not assisted by selected gobbets of earlier evidence being placed before Mr. Hops for his comment. And that, in our submission, is what my learned friend is trying to do again on this appeal, is to try and say, well, actually, there was some evidence of altering the heater to heat different portions for different durations or temperatures. Look at these gobbets. And we say, firstly, he didn't get where he needed to with Mr. Hops, and at best he started putting the case on, you could do this, you could do that. And in any event, the judge rejected that, and we say, it gets nowhere now. So my lord, we say that the position on the evidence is that in light of DV and the common general knowledge, whilst it's possible to configure a thin film heater to heat in almost any way, including heating different portions for different durations or temperatures, there isn't the evidence that this was obvious to do in light of DV or the heat not burn products of repaid or common general knowledge, and one can see why, because they do something different. There was no reason to think to do it, and it's not obvious to do it. And in fact, we say that this prior art points away from the invention and not towards it. And we say that what went wrong here is the approach the judge took, not just to the claims, but to his approach to obviousness in not assessing properly the distinctions between the prior art and the patent, and then confusing what skilled teams are able to do within their skill and what is obvious to do over a piece of prior art that was flawed. And for those reasons, my lord, we say this appeal ought to be allowed.
Thank you. Mr. Speck.
Can I give you a roadmap of what I intend to cover to start with, please? First, I'm going to spend a little bit of time to identify the distinct issues that arose in the case before the judge. This will include showing my lord some of the judge's findings and conclusions, but also some evidence that supported them. And I'm doing so because in my submission it's important to ensure my lords keep your eye on the ball. What my learned friend is seeking to do is to muddy the waters in this appeal, and in particular what he's really seeking to do is to undo findings as to fact, conclusions or assessments as to obviousness, which we say ought not to be susceptible to interference in this court. You'll have noted his skeleton says they're very mindful that wouldn't be appropriate, but that's exactly what he's trying to do. And in particular, what he's trying to undo is the findings that my lord Christopher Floyd has put a finger on. He's actually trying to get at the variation in duration and temperature of what he's actually framed in his grounds of appeal as his four principal errors of principle in paragraph 2. Got nothing to do with that. So I'm going to take some time to identify some important aspects that go to that. Secondly, I'm going to take some time to look at the patents, what their disclosure is really getting at, both in terms of the technical teaching, but also what's presented as the contribution, in particular the two aspects that are identified, neither of which has got anything to do with the so-called invention my friend's clients have now sought to craft in the various recast claims of all four patents. I'm going to do it like my friend and the judge by focusing on 486, but I do invite my lords not to lose sight of the fact that the judge had four different patents based upon the same disclosure. And it's not just those four different sets of claims, the various amendments that were advanced as well. And that may be why the judge focused on particular questions that have been formulated by my friend rather than to look at endless claims again and again and again. Third and finally, I'm going to turn to address the four specific points my friend has identified and advanced in his skeleton as to the errors. They're conveniently summarised in paragraph 2, and actually by the time I get there I can take it very quickly. So can I start by making sure we've identified, and we very clearly have in mind, distinct points that arose. And it's particularly important because what he's doing is dressing up an appeal about an alleged error in construction, specifically as to whether the claims cover heaters with multiple but physically separate tracks that provide portional heating, as opposed to a contiguous single track where connectors can be made at different points. And he builds on that point, that single point, that distinction, which is his first point in paragraph 2 of his skeleton, and all the remaining points are focused on that distinction or difference, namely between having physically separate tracks or a single contiguous track where you can tap off connectors at different points. All the remaining points build on that distinction. So point 2 in my friend's list is the suggestion the judge asked the wrong question. Essentially, he's saying he erroneously considered whether something not actually in the claim was obvious. That's the point of that ground. Point 3 is a suggestion that the part of the judgment where the judge explained both ways to implement portional heating arrangement were obvious. He somehow muddled up his task and asked himself whether those approaches were obvious over the patent. That's his third ground. And the fourth point is a suggestion that there is a material difference between those two arrangements. And my lord Sir Christopher Floyd has asked him about that, and he wasn't able to tell you why there was a material difference between those distinctions. And that's why I say he's dressing up his appeal, because what he is really seeking to attack are the judge's conclusions on the evidence as it being obvious to provide an arrangement that may first heat to different temperatures and secondly heat for different durations. And he knows any attempt to advance his appeal on that directly will fail as an attempt to re-argue overall assessments or conclusions on the evidence. And just to be clear, to identify that as a separate point, can I ask you just to consider this, a very simple arrangement, as in fact the judge did, with just one single track, no portions, one contiguous conductive track providing a single heating region. So the entire aerosol forming substrate, whether it be tobacco, whatever it is heated when the heater is connected to the power, not when it's not. And it's the same heater used for each puff. And in that context, the different durations or different temperature point may simply be this. One may decide one wants to be able to heat to different temperatures at different times. One may decide one might want to wish to heat to for different durations. And let me give you some really simple examples. Having the heater to provide heat through the whole duration of a puff, whether it be a short, sharp puff or a long, slow drag. So having the heater actually doing its job and liberating aerosol throughout the puff. One may perhaps do that most simply manually with a touch button that closes an electric circuit for the duration that the user holds it down, or in a more convenient automatic way by using a puff sensor which senses the puff being taken and keeps the heater on during that period, be it short or long. Another simple example is ensuring that the tobacco or other aerosol forming substrate is to some extent preheated so that the jump in temperature required when a puff is taken, that quick jump, is not too large. And also it makes no difference if one starts with the device taken from a very cold place. And the point I want my lords to see at this stage is that this is a separate point to portional heating. It arises in this simple one-track heater arrangement. But of course, if one is also deciding to adopt portional heating, say different portions of the aerosol forming substrate are to be heated for each separate puff, take that as a paradigm example, one can readily see how the same applies. One would equally desire to control the duration of the heating to equate to the length of the puff, even when one is only heating a portion each time a puff is taken. And one would equally desire to be able to preheat to a particular temperature, at least the next portion, perhaps the whole thing, to make sure that you're not jumping through that much larger temperature jump. Now, it's important in my submission to draw my Lord's attention to the judge's findings concerning this dimension of the case. I'm going to do that first, if I may. And can I start with the judgment? So we're in tab 8 of the core bundle, para 119. I think it's a paragraph that my learned friend has already referred to. And it's the particular paragraph I wanted to take my lords to. It's quite a long one. Page 133, it's subparagraph 4, subparagraph D. And this, just to put you into context, is a section on the common general knowledge of resistive heaters. It's directed to how they are controlled. We see the judge is also explaining control including as to temperature and the duration of the application of the heat. The footnote is to Mr. Wensley's evidence.
Sorry, I've lost where you are, Mr.
Yeah. Page 133 of the core bundle.
Thank you.
It's in the judgment. It's not so easy to see precisely what the paragraph number is because it's one of those very long paragraphs, but it's 1194 little d, so it's in the middle of the page.
Thank you.
And I was explaining that he's made a reference to Mr. Wensley's evidence. The judge also explains the triggering of heating automatically or through user choice by pressing a button. Again, Mr. Wensley's evidence is relied upon. And the final point in this paragraph is temperature itself being monitored and closely and controlled by way of closed loop or feedback control. Now, can I just show you the evidence that's referred to in that paragraph? First, Mr. Wensley, supplemental bundle. That's tab 7, page 121. You see the section headed electronic control by the bottom hole. And the judge referred to the entirety of 82 through to 84, I think, in those two footnotes. But just see, for example, the beginning of paragraph 83, explaining that the control circuitry in an HNB, that's heat not burn device, would need to control temperature and length of heater activation. A basic requirement, said Mr. Wensley. Too much heat may burn the tobacco, too little may not liberate the desired amount of aerosol. The judge relied on the passage all the way through to 84. I'm not going to read it all out here. That's the nature of the underlying evidence. Can I show my lords the transcript reference given by the judge in that part of the judgment as well. It's tab 11. Page 303, and we've been a little bit over keen, I'm afraid, in giving my lords only their absolute bare minimum. There are a couple of pages that we should have given you either side of 303, because page 126 of the transcript is actually where the judge referred to it. So can I hand up some additional pages to insert either side of that? Just one page to go in front and one page to go behind. So what my lords have got there is something to go in front of 303 and something to go behind, so that you actually have a better extract. And you'll recall that the judge actually referred to page 126. And this is me cross-examining Mr. Hops, my friend's expert, as to the common general knowledge of the skilled team in this field. And you see at the top of the page, we're moving to consider sensors. And the first topic we cover at lines 5 down through page 126 is open loop and closed loop control. And it's specifically, we see line 18, Mr. Hops accepting closed loop control would be very well known. You see, for example, the passage from the foot of the page, line 25 through to 127, line 11. We talk about the desirability of controlling temperature more accurately, and this being very well known, to which Mr. Hops agreed. It was desirable in some situations, balanced against the cost of implementation, which you see at lines 8 to 11, he agreed with the point that the proliferation of cheap computer processors meant it could be done digitally and was well established. And this important passage continues for some length. If we read on over the page and pick it up at 129, you see the topic turns to preheating. See line 6. And the passage culminates on page 130, line 7 to 131, line 19, where we see two purposes as to why the skilled person would have preheated. Mr. Hops agrees with them, and he also agrees with the use of the closed loop feedback. Now, my lords, please note why we're here. The preheating itself requires different durations too, turned on and off, different times. See the question and answer at page 131, lines 14 to 19. Also worth looking at is the passage bridging the page over to the top of page 132. This is where Mr. Hops is recognising that thermal insulation will be included as necessary, something that was live before the judge, not before my lords. But one of the points he specifically identifies, it depends upon the duration of the heating. See that at the top of page 132. So, Lord, that's the first passage in the judgment and the underlying materials referred to that I'd like my lords to have in mind. The second passage is the paragraph 132 on page 137 of the bundle. Something that my friend's been to already. And it's important. Here the judge is making findings and drawing conclusions as to obviousness. Just to put you in context, the section with that title starts at the foot of the previous page. So that's what he's doing here. And at this stage, he's concluded that the use of a thin film resistive heater as a means to envelop an insertable tobacco product was entirely obvious over DV. And the point he turns to consider the different durations or the different temperature points. And as I foreshadowed, he does it by starting with consideration of the simple position such as a heater with just a single track. And we see at para 132, the judge says, leaving aside the portions element of the claim and focusing on single conductive track, it's quite obvious. Indeed, he explains it was known. As you see in the middle of the paragraph, his conclusion, it was old technology. So that's a conclusion, it's obvious in the context of a single track. One might ask why it would be different where one only heats portions. Why not preheat the next portion, for instance? Why not control the heating of that portion to correspond to the duration of the puff? When in fact it's worse for my friends, because DV, which is of course the starting point for obviousness, has portional heating in the sense that it's got separate heating regions to heat different portions, actually discloses control of the duration of the heating. Now I know my lords are aware that the judge held that to be so, but it does it in two ways. One is manual, by keeping the button pressed, and the second is by built-in or automatic control. And they're probably both fatal to my friend's argument because they both require electronic circuitry to control the supply of power in accordance with the claim. Being manual doesn't take it out of the claim, but either way, the second automatic one undoubtedly is in the claim. Can I show you both, please? We need the supplementary bundle, so we're going to go to DV. Tab 5, column 3, the first manual way. My learned friend touched on this very briefly, but shied away from the key passage, or the key explanation. The first bit is lines 40 to 45, where it describes the manual selection of the heater element and pressing a momentary on push button to complete the circuit. It's important for you to understand what that is, and I'm going to show you the evidence that establishes it, but it's one that closes and completes the circuit when pressed. So the duration of the heating is controlled by the user by how long it's kept pressed.
Well, that's reading a bit into it, isn't it?
Pardon?
Reading a bit into it, it could be like...
Well, I'm going to show
Mr.
you the
Nichols
evidence. I'm going to show you the
says
evidence
like
that
a cap
establishes.
gun fires off a fixed charge, as it were, or it stays on as long as you press it.
I'm going to show you the evidence. That was the subject of cross-examination.
You're not saying get that out of the lang.
No, I'm telling you that's what it is, and we're going to see it in the evidence, and we'll see Mr. Nicoventures moving on quite sharpish when he got that evidence. But that's what it is. He doesn't like that fact. That's why he didn't mention it. Let me show you that now. It's tab 13. Page 322 of the bundle. Page 359 of the manuscript. And at the top we see Mr. Nicoventures had just colourfully described the selection of which heating element is to be used as a bit like Russian roulette, something that he mirrored again today. That's line 4. And that's where, because one's twirling a knob to line up which barrel of the gun's going to fire off next. But you see the attempt at the question at line 12 to suggest the momentary on button is not one where one can keep it on. The idea suggested by my friend is obviously that the user has no control over duration. But Mr. Wensley explained the contact is closed with it being held down. Goes on to explain it doesn't change state, and as I understand that, that's a rebuttal of the suggestion, because if it would change state, it then diverts off to a different state where it's doing something for a fixed period of time, regardless of the button being held down. That's a kind of state machine parlance way of looking at it. But it's quite clear the answer is the circuit is closed while the button is held down. So the user controls duration by holding it down. And Mr. Nicoventures quickly moves on. That's the first way it's done. So that's context for what you then see in the next column, in the next passage down in DV, you've already got something which is manually synchronised to when you want to be taking a puff. What DV does, so I'm back in tab 5, is it explains a little bit about how the air comes in and then turns at the foot of the column, this is lines 63 to 68, that it's more preferred to include controls that automatically select the charge, so you don't play Russian roulette, and automatically initiate the heating in response to a stimulus such as a puff, and to control the duration. Now, it's true that Mr. Hops had suggested, unlike the manual arrangement, this was just initiating a fixed duration. But note, my learned friend said it's only the bottom of this column where there's any dispute. There's no dispute about the manual one above, and I'm not surprised about that because I'm going to show you the transcript. Can I show you supplemental bundle page 308? So this is tab 11. We look right at the bottom of the left-hand side, the last couple of lines of page 157. I'm firstly addressing the manual version with Mr. Hops. And I suggested to him that it's easy to make but a bit involved to use. The user has to select the heating element to be used, remember which ones have already been used, and he has to synchronise and press the button when puffing, and he agreed. Lines 5 on page 158 of the manuscript. The user has to synchronise to press when puffing. I then tackled the text concerning the automated version with Mr. Hops from line 6, and we see at line 21 I suggested to him the basic idea is the same, namely to still be powering the heater when the user is puffing but not otherwise, but not relying on the user pressing the button. And it's here he sought to suggest it was different, suggesting in this case the heating initiated would be for a fixed duration. You've seen that. My friend took you to it already, I think. It's the answer spanning pages 158 to 159. We continue to debate it, and what we have at the end is Mr. Hops accepting that what he's suggesting is just not controlling the duration at all. See that in lines 14 to 16. That's not the end of it, my lords, because if you go forward to page 310, this is a passage of where I was taking stock of what the person sees in DV. So I'd been through the disclosure and I was taking stock in a passage. You can see that I'm doing that. If you look at 172, around about line 20, I explain that's what we're going to do. But the part I want to show, my lords, is page 175 of the manuscript. You see Mr. Hops agreeing in this taking stock section that DV contemplates a mode of operation with different portions separately connectable to the power supply to be powered during a puff but not otherwise. That's lines 14 to 17. So, my lord, it's hardly surprising in the light of all this evidence, including the fact that the manual version plainly is controlling duration, and indeed from the judge's conclusions earlier in para 132, that such control was obvious, not new technology for a single track device, and indeed just from the language of DV at the bottom of column 3, that the judge came to the conclusion that he articulated at the end of paragraph 132, i.e. that DV was disclosing that. DV was disclosing control of duration of heating, which provided for variation of duration. And my lords, it's not just the judge, he's doing exactly the same thing as the opposition division did. Can I just show briefly that? I'm afraid it's not found its way into the bundles, but Miss Pickard's brought copies. It's exactly the same thing that the opposition division did. This is the opposition division decision on 486. And what it does when addressing what's disclosed in DV is set it out what its conclusions as to what's disclosed in a table. And so what you need is paragraph 58, which is on sheet number 14 using the numbers at the top. And it does it by what D10 is DV. It's addressing what's disclosed, and it says which integers are disclosed, and the key integer is integer 1f. And we see it identifying column 3, lines 63 to 68. The bits in brackets have been added by the opposition division. So in 1f, last box in the table, it says controlling the duration of heating of each flavour charge, see column 3, lines 63 to 68. It's disclosing heating for different durations. And you see what they've done for that integer is to cross out different temperatures or both, because they weren't finding that it disclosed that. Before we put it away, can I just ask you to note on a point that we're going to come to save coming back to it, paragraph 54, this is on the point of construction. The opposition division construed the claim in the same way the judge did. It does not require each track to comprise a plurality of portions. One or more conductive tracks can correspond to the plurality of portions. And I'm going to come back to that and why the judge is right on construction.
You are supporting the judge on construction.
Yes, yes.
Wasn't able to detect that from your skeleton arm.
Well, I noted, I think it was an intervention from my Lord Justice Arnold. Perhaps we weren't as firm and as fair to the judge. It was just irrelevant to the judge's deciding on the appeal, but I will explain to my lords why the judge is right. It's an important part of understanding the totality of the patent. So I am going to support the judge.
Well, if the judge is right on construction, then your target for obviousness is wider. You don't have to worry about portions of a single track.
Indeed, indeed, indeed. But the reality is, the case isn't about that. It's about this different temperature. What my friend is trying to do is to undo the assessment of it being obvious to have different temperatures or different durations as the way you heat. And that's why I've tried to start with that, because he's tried to dress it up as something which just isn't. The final passage of evidence to show you on the topic of DV is tab 12. So I'm still in the transcript on page 312, and it's basically picking up right at the beginning of 192, and it's the passage that goes all the way through to the first line of 194. What you get here is some evidence about how this is directed to how a skilled team considering DV and how they'd implement a system with a permanent thin film heater with a cigarette type consumable. So the very thing the judge concluded was obvious, and you see at the beginning of that passage, so at the top of 192, the judge, we go straight into closed loop control, agreed to be a useful thing to incorporate, that's lines 7 to 12. Puff actuators to limit heating to the time when the user is taking a puff, helpful, see that agreed at 13 to 15. Preheating also agreed in lines 16 onwards with a closed loop system, that's down to line 4 of 193. And both preheating just the next portion or the whole thing, so you can do it either way, both agreed to be obvious, that's down to line 16. And the final point here is that the time period over which each portion is subject to preheating would vary depending on how long is left between the puffs. That's line 17, page 193, down to line 2 at the top of page 194. It's ample material, my lords. And I've taken some time to explain this different temperatures and different durations point, which is a separate point to the portions issue, because that's really what he's getting at. Every time you hear him talk about flash heating or see it in his skeleton, he's seeking to suggest, contrary to those findings, that there's a mindset of always having no control whatsoever over temperature or duration of the heating. Only ever simply have the most basic application of power for a fixed period of time. And incidentally, before we move off of it, while it's in my mind, my learned friend sought to rely on that passage in DV on the next page. I think it was in column 5, which comes after the explanation that you control when it's heating with a button or control duration automatically. He relies upon column 5, so I'm back in DV, and the calculations and description given there. In particular, I think he's talking about being able to heat to at least 450 degrees during a pulse of less than 1 second. Towards that is setting out the kind of characteristics for the battery that you need, the kind of power, the energy that you're going to have to get out, both total amount of energy and the rate. It is not telling you that the duration won't be controlled. It's just telling you this is the kind of thing that you've got to achieve. So that section is not saying all we're talking about is a fixed duration. It's actually telling you this is the kind of thing that is going to be needed to be achieved, but it doesn't detract in any way from what's referred to earlier about being able to control the duration of the heating either by the momentary on button or by the automatic electronic controls. It's just saying this is the kind of thing that's going to be designed. Here are the calculations.
Well, the oddity about the passage at column 3 is that nowhere it says that the user releases the momentary on button.
Well, no, but that's what a momentary on button is. You saw the evidence from
Well, my understanding of the expert evidence was that it doesn't change state after you've pressed it.
Yeah.
So why is that not consistent with pressing it, a fixed charge being delivered, and the user not having to do anything further?
Oh, that is a change of state model. The language in state machine parlance is if you press a button, you cause it to go off and do something else. It's in a different state. If you're just changing it physically, so that by taking your finger off the button, it's always in the same state. You're not changing the state of the machine. By pressing a button and moving it into a different state, you cause it to do something which is a fixed period. That would be a change of state. It's quite clear in that passage that he's talking about the thing only heating while you've got your finger on the button closing the loop.
Okay.
So, my lords, that's what it's really about, trying to undo that. And I've shown you the underlying materials for 2 reasons. Firstly, to make sure you're satisfied there's ample material for the judge's findings on this. But secondly, because there's a suggestion in my friend's skeleton that the heating of different portions to different temperatures or different durations would be a departure, and that Mr. Hops was significant departure. Mr. Hops was unchallenged on this. This is my friend's skeleton, para 48. Simply wrong. I've shown you I was tackling Mr. Hops on this issue, including specifically in the context of what DV discloses and would suggest. And far from me not challenging him, you've seen he accepted that in DV the manual control required synchronisation while puffing. He accepted the suggestion that the automatic preferred embodiment being different would not be control of duration at all. And he went on to accept that the way to implement a DV-type device using a thin film heater, permanent thin film heater and cigarette-type consumable, would be to utilise temperature sensors, closed-loop control, and heating both to different temperatures, at least for a preheat, and different durations for the puff. I did challenge him, and he he actually accepted what I was putting to him. Can I move on and look at the patents, please? And I'm going to do the same as my friend and the judge, and that can focus on 486. So we're in Supplemental Bundle Tab 1. And before I start looking at the text, can I just give my lords an overview of what we're going to see? We'll see an explanation of what the inventor actually thought was invented when the text was composed, and it's namely two things, what are described as two aspects. And just for your note, the judge picks out those two aspects at paragraphs 50 and 51 of the judgment 2. And the first aspect is the construction of a heater using resistive heater tracks laid down on a substrate where the heater tracks can themselves be used to monitor the temperature. And the point is, if you use material whose resistivity varies with temperature and is dependent upon temperature, one can, by monitoring voltage and current, just using Ohm's law, you can actually work out what the resistance of the resistor is, and it varies because it varies with temperature. So you get a measure of temperature too. That's the point of the first aspect. And the point, the benefits is it's said to simplify the device or its heater, eliminating separate temperature sensors, making it simpler to manufacture. And the second aspect the document focuses on is to provide a thermally insulating part to insulate the heater. And the real focus of that is the provision of it efficiently on perhaps the same substrate, ideally the same piece as the heater itself. And we'll come on to how the disclosure proposes that's achieved. It's a honeycomb structure. And that's how one gets to the peculiarity of the suggestion that a preferred feature is a thermal insulator made of metal, because metal generally is a conductor. It's because it gives you air pockets. So that's the focus of the second aspect. Now, just a word about that before we get into the detail. I think you've picked it up already, but that second aspect, the judge has both decided was severable in a Sabbath sense and obvious because of a different piece of art called Moynes. And so that's not live before my lords. Now, when one looks at the aspects, again, before we get into it, as is conventional, you often see different or the same thing described different ways. For instance, a feature of a product or a method. And we see that done here, and we will see that basically the first aspect is described both as a smoking device, a heater for use in a smoking device, and the use of the heater in the smoking device, but it's all the same thing. So with that overview, can we just pick up the patent and look at what we see where? And what I want to do is just give my lords some navigation. First thing I want you to note, please, is the title, consistent with the points I've just been making, Electrically Heated Smoking System with Improved Heater. And the text in paras 7 to 10 introduces the first aspect, that's the resistive tracks, which can also be used as temperature sensors. Para 11 starts on a list of things that can be adopted, preferable things that can be adopted with it. And actually the way this works is it culminates with the second aspect can preferably be adopted, that's paragraph 13. And they do the same at the end of the list of preferable things that can be adopted with the first aspect. Now, can I just pause to make a few points in relation to this description of the aspects? The first aspect of the disclosure, as I've said, is the use of the variable resistivity tracks so that you can actually use them to measure the temperature as well. And that's described up to and including para 10, where we see the benefit that's identified in para 10. Can you look, please, at that? We see in lines 8 and 9, the benefit is the reduction in the number and the size of the components required in the electrically heated smoking system. And at lines 16 to 19, we see more straightforward manufacturing identified. These are identified as benefits of using a heater with conductive tracks on an insulating substrate that can be used as both heater and temperature sensor. That's the introductory text of this passage. See para 10 lines 5 to 7. And the reason I'm labouring this point is because my lords should be surprised when we see this passage relied upon by my friend as something provided by the invention his clients have completely reformulated, which has got nothing to do with this dual purpose feature, but rely upon it he does. It's his skeleton paragraph 28. You see the last few lines. Can I make a further point about this paragraph? The disclosure of this paragraph and of the patent generally, the reduction in components, if the heater track can also be the temperature sensor, is premised upon the skilled person otherwise, i.e. without the invention, adopting separate temperature sensors. The whole premise of what they're describing is that if you don't have the invention, you would have separate temperature sensors. Just pause and consider that. It's telling you that the benefit is to eliminate them, but why would you have them? Why would you have them? Because you are controlling the heating, either as to the temperature reached or the duration. So the premise of this disclosure is actually that you would otherwise, without the invention, have temperature sensors and be controlling it. So it's a point that I make about the thrust of the case that's against me, is that actually the patent is not only not directed to it, but it's actually premised on the opposite, that you would have temperature sensors and be controlling it. Now, the key passage, my lords, that you're aware of on the construction issue is 22 to 23. And I'm going to come back to that once I've shown you what the rest of the disclosure discloses. And I want to do it just very briefly so you see what else is there. There's a lengthy passage from Power 24 that sets out each and every way one may think of configuring the heater. Make it rigid, roll it up, so on and so forth. And that goes all the way through to paragraphs 28. There's extensive disclosure of the precise materials one may use, both for the resistive tracks, but also the insulating substrate. That's 29 to 31. There's also extensive disclosure as to the methods of manufacture. That's addressed from para 32 onwards, where suggestions are made for the materials that you're going to use for each of the different methods. And that continues right the way through to paragraph 38. And then there's a different section on different forms of aerosol forming material described. This is lengthy, right through to 47. Just note here, this is covering just about everything. It's not just a tobacco substrate. Again, contrary to the impression my friend Skeleton gives at paragraph 27, which suggests the invention is only about external heaters wrapped around a cigarette-like insert. You've got absolutely everything in here. You've got liquid aerosol forming substrates described in paras 44 to 46. Not what the invention was directed to. It's directed to the improved heater of the kind that we've identified that would work with any kind of aerosol forming substrate. Now the figures. The figures concentrate on methods of manufacture first, and one can see that from the summary in para 52 and indeed 53 lines 49 to 52. All of the first three figures are directed to manufacturing process. You don't see anything there that sheds any light on what the whole device looks like or how the heating tracks are configured. Figures 4 and 5 do show two alternative embodiments for the heater. This is important, just so that you know where I'm going. Neither of them are in the claim on my friend's construction. Figure 4 is a flat rigid heater with tracks on, so is used as an internal heater. We see its insertion into the plug aerosol forming substrate shown schematically in the figure on page 16 of the bundle. The tube 407 is the plug of aerosol forming substrate, and it's described in column 13 from para 27, and the description mentions that the tracks can act as temperature sensors if made of suitable material. That's line 27 or so in column 13, and at lines 29 to 32 it says it can be combined with the thermal insulating material. So the suggestion is this can be part of a device in accordance with both of the two aspects I've described, with the tracks operating as a temperature sensor. But if you look again at the actual diagram on page 15 of the patent, 16 of the bundle, we can see two separate heater tracks on the surface facing us. It doesn't say, but I suppose there might be the same on the reverse side. But the key thing for my lords to take from this is that the tracks are two separate tracks, each a very long elongated loop as it were. Two physically separate tracks of conductive resistive material, but consistent with the focus of the document, being the two aspects we've described, the text doesn't even mention the level of detail as to it being portions or anything like that. The other embodiment, figure 5, is focused on showing how a single piece of electrically insulating substrate can be taken and used to provide a heater and the insulating material in one. So on the left hand side we see a single track deposited on the substrate. It weaves up and down and then returns along the bottom, and the track terminates at the two connectors identified 505 through which the power is connected. And the right hand side shows an area of substrate which has the hexagonal honeycomb structure printed on it. Described in column 13, line 40. Text there goes on to explain, this is line 42 to 47. It's designed to be rolled up with the conductive track on the inside and the insulating bit on the outside. And that's what you see illustrated rather crudely in figure 5b. So it's intended to be used as an external heater with the heating bit inside, and the aerosol forming substrate will be inserted inside that. But what is shown is a single contiguous line of conductive material terminating at either end by those conductors. You should note, connectors. You should note that the text in some parts does describe it as tracks plural. See, for example, para 73, lines 37, even though what's shown is a single contiguous line. And it may be that the draftsman considered a single contiguous line of conductive material where it travels in opposite directions is apt to be described as tracks plural. In the context of a document focused on the two aspects we've been discussing, that wouldn't at all be noteworthy, but of course really matters because of the view my friend now takes of the invention. But in any event, either way, it's fair to say the diagram really focuses on illustrating the provision of the piece of substrate that has the heating material and the insulating material, and only shows a single track in the drawings. And the point of showing, my lords, the detail of those two figures, looking at what's seen in all the figures, is that the first three figures don't show you anything that can help you on this at all. But the detail of the last two figures, you've got one, figure 5, that doesn't provide portional heating capacity at all, because it's a single track. Figure 4 shows two separate heater tracks, possibly more on the reverse. So although the text doesn't suggest powering them separately, if you did decide to do that, they're physically separate conductive tracks connected separately. So neither of them are in accordance with what my friend now says is the scope of his claim. Can we now look at the key passages in paragraphs 22 and 23? So back at column 4. And the first point I want to make to my lords, is that the language at the beginning of 22, the one or more electrically conductive tracks comprising a plurality of portions, is the language of the claim. There was a lot of criticism levelled by my friend suggesting, oh, the judge should have looked at the language of the claim. He's looking at a passage which does have the language of the claim at the beginning of it. Para 22 explains that one or more electrically conductive tracks comprise a plurality of portions, each portion being separately connectable to the power supply. So the key is that there are a plurality of portions, and the key characteristic that you're told, text at line 8 and 9 tells you that the key characteristic of a portion, separate connectability to the power supply. If we read on, this gives a number of advantages. First, it allows different portions to be heated for different durations, which may enhance the smoking experience. That's lines 10 to 13. Second, it allows different portions to be heated to different temperatures, may also enhance the experience. That's lines 13 to 16. And third, it allows a particular portion of the heater to be activated at any time. So you can have only a portion of the aerosol forming substrate heated at any one time. All of those advantages flow from the point identified as the key at the start of this paragraph, separate connectability to the power supply. My lords, while we're looking at it, please also note that line 17, what is being referred to is a particular portion of the heater. Line 17, portion of the heater. This is all about the heater being in portions so that different portions are separately connectable to the power supply. And all of those benefits flow from it. So, turning to the dispute in hand, does the claim, indeed the language at the beginning of 22, paragraph 22, does the claim exclude a heater made up of a plurality of physically separate tracks, each separately connectable to the power supply? That's the essence of the dispute. You'll have seen the opposition division say, no it doesn't. The first point I want to make about that is that such an arrangement, the separate tracks separately connectable, does have the key characteristic, separate connectability to the power supply. Second point I make, as a result, it provides all of the benefits identified in paragraph 22. Third, it provides a heater that is configured in portions, as is the focus of line 17. Technically, it is full square within the purpose. Is it also in the language? Lords, we submit it is. And the reason for this, ask yourselves, what has to comprise a plurality of portions? The answer is the one or more electrically conductive tracks. In other words, the whole of that covered by the phrase, the one or more electrically conductive tracks, must comprise a plurality of portions. Whole ensemble. Whether it be 1, 2, 3, whatever number of electrically conductive tracks, that collection must, when you look at it, comprise a plurality of portions within the meaning of what's described here. And to be clear, one can do that with a single contiguous line of conductive material where one can initially connect, say, at one end and an intermediate point, and separately at a different point in time connect to the different intermediate point, or even the same one, and the other end. There you'd have one contiguous track with two portions. So you can do it that way. Or another way to do it would be to provide a plurality of separate electrically conductive tracks, say just two in a simple example, each of which are separately connectable to the power supply. Each would be apportioned, so the one or more electrically conductive tracks in that case would be two, and those two, as they're each a portion, would collectively comprise a plurality of portions.
And is that what's referred to in the last sentence of paragraph 23?
You're ahead of me, my lord, yes. Because 23 tells you two ways in which you can do it.
And those embodiments, you say, are embodiments of what's been described in 22?
Absolutely. My lord's well ahead of me. 23 is telling you precisely two ways to implement what I've just told you about in 22. You could imagine other arrangements, perhaps having a hybrid of one track of one type and another of another. But as my Lord Justice Nugee has just preempted, it's not just that you could anticipate that. That's what paragraph 23 specifically makes clear. Two ways in which the detail of the disclosure of 22 may be achieved. And it's not without note that the first way is a single track, where you have to have portions in the single track. The second embodiment, lines 31 to line 23, it's not one or more, it has to be a plurality where they're of this kind. Has to be a plurality, because obviously if you've got no chopping them up, you get your portions from having two or more of the separate ones. And so the second half of paragraph 23 is exactly another way of doing it, but note that it has to be, and the text says it is a plurality. So that's exactly why both of them are within it. And just to complete the submission on this bit before we look at the way the judge dealt with it, because in substance he's doing the same as the reasoning that I've just set out. But just so that my lords have got the point, not only does my friend's construction involve him saying that none of the figures are actually covered, his construction involves him saying, even here, where it's specifically telling you two ways to do this thing which is now in the claim, only one of them is covered on his construction of these words. His case, and he made it quite plain this morning, that he says that that second embodiment in 23 is excluded. And I say it's not. It is a second way of doing precisely what 22 is about, which is what the claim integer is about. And it gives you all the advantages that the patent says you get from doing it, and it has the key characteristic that the things which are portions are separately connectable.
So your construction involves saying that a portion can be a whole track.
It depends what it's a portion of. Yes, exactly, it can.
Yeah.
Yeah, because
I mean, take the case of two tracks with no portions within each track. You read the claim. You've got two electrically conductive tracks, and then it says the two, substituting two for one or more, electrically conductive tracks comprising a plurality of portion. Well, if the track is the portion, that doesn't really tell you very much. It is slightly odd.
well, do you know what it flows from? It flows from the fact that if that language was something which itself was not a set of individual things, you wouldn't have any problem with it. And because we're talking about a portion and the thing is a set of different things, you can either ask yourself, is it a portion of the whole ensemble,
Yeah.
or is it a portion of the individual things that are mentioned there? And my submission, it's the whole ensemble, and it gives you exactly what you want, and it tells you that by 23 in the second way of doing it. It makes it absolutely clear. But it does flow from that. Really, the question is a portion of what? A portion of the whole ensemble, or a portion of the.
Then if you've just got one track, not much of an ensemble, there's one track, and the portions.
Then it has to be a subdivided track.
It does have to be subdivided.
Because you've only got heating in one thing, so you have to subdivide that. But if you've got a collection of two or more, the subdivision can come from the individual members. That's the point.
And when it says in 22 line 17, portion of the heater,
Yeah,
you say that's what portions means throughout these paragraphs,
absolutely. The key question is portion of what?
not portions of tracks,
No.
which is how you might read it, and indeed how it is said you should read it.
Yeah, indeed.
And you say that's wrong. It's
That's why.
it's portions of heater.
That's why I emphasise line 17, because what it's telling you about is what it really wants to have are portions of heater, each of which are separately connectable. Now, how you achieve that, whether it be by one track, which has separate regions connectable, or multiple tracks that are each separately connectable, doesn't matter. And indeed, as I said a few minutes ago, you could even consider a hybrid where you've got one track that's on its own and another that's... You've still got portions of heater. That's why line 17 is significant, as is the key characteristic, separate connectability. I've trespassed on my lord's lunchtime. Sorry.
Not by much. Very good. We'll pause there and resume at 2 o'clock.